Hi, everyone. Thank you so much for joining us for this CLE today with DAYL. To begin with, our topic is going to be covering the Corporate Transparency Act that is to go into effect in January 2024. For a very brief overview, this 1-hour CLE is going to be discussing what the Corporate Transparency Act is, as well as why it was enacted, what the significances of the implementation are, and then how do the reporting guidelines change. We are going to have the Q&A open for anyone who wants to ask questions throughout our CLE, and then I will take your questions and ask them to our panelists if we have extra time. By way of introduction to our panelists, I would like to start off by introducing Marosh Nawaz. Marosh has her own law firm and she works closely with the DFW community. She represents small to medium-sized businesses, and her firm assists them in setting up and running shop. The clients receive assistance in guiding them through and around the various rules associated with their specific industries. Specifically, Marosh Nawaz represents store owners, home health companies, smaller health and pharma-related corporations, including spas, various medical service providers, and medical equipment companies. Our second panelist is Ron Rode. Ron Rode is a seasoned real estate attorney specializing in investment acquisitions, dispositions, and triple net leasing. What distinguishes Ron in his unique role as both a legal expert and a successful industrial triple net investor is that he has represented over $1 billion in real estate transactions across diverse property classes, including multifamily, industrial, and retail. As a principal, he currently owns a robust portfolio comprising of over 120,000 square feet of industrial triple net properties with 15 acres of outdoor storage. He also offers valuable insights to help you via YouTube and Twitter, so hit that follow. Our third panelist is going to be Sam Smith. Sam is a founding partner of Hamada Smith, a business law firm. His practice focuses on advising clients on securities matters, including private securities offerings, commercial real estate syndications, and fund formations. Thank you so much to our panelists for joining us today for today's CLE. So I think the very first thing that we're going to start off with is the most obvious question, right? What is the Corporate Transparency Act of 2024? And if one of our panelists could kindly please explain the bill and what it stands for.
I can take that. The Corporate Transparency Act of 2024 is a federal law passed to enhance transparency and accountability in corporate activities across the U.S. A brief summary of its key provisions. We have to have beneficial ownership disclosure. Under this act, corporations and limited liability companies are required to disclose their beneficial ownership information to the Financial Crimes Enforcement Network, FinCEN. This information includes identities of individuals who directly or indirectly own or control 25% or more of the company's ownership interests. There are reporting requirements that the companies must file a report by the end of 2024 if there are companies which were established before 2024, and for companies after the 1st of January 2024, they have 1 month to do so. This filing will be done with FinCEN, and it details their beneficial ownership information, and any changes in the ownership must be reported within the year. Any discrepancies or errors must be corrected promptly. There are penalties for non-compliance. Companies failing to comply with the disclosure requirements or providing false information may face civil or criminal penalties. Directors, officers, and employees as well involved in non-compliance may also be held liable. This would also include CPAs or attorneys that are helping do this disclosure for their clients. The access to information is being limited. Federal and state law enforcement agencies, as well as financial institutions, will have access to beneficial ownership information for investigative and anti-money laundering purposes. This will help combat illicit financial activities. Protection of personal information has been put into place as the Act includes safeguards to protect the personal information of these beneficial owners. There are some exemptions for certain entities such as publicly traded companies, some financial institutions, and some small businesses meeting specific criteria, and they may be exempt from some or all of the reporting requirements. The Act aims to coordinate with state governments to streamline reporting and reduce duplicative requirements. States are encouraged to provide FinCEN with their own beneficial ownership information for centralized access. In summary, the CTA is designed to combat money laundering, terrorism financing, and other illicit financial activities by enhancing corporate transparency through mandatory reporting of beneficial ownership information. It imposes stringent disclosure requirements on businesses while protecting the privacy of the beneficial owners. Compliance with this law is crucial for corporations and LLCs and other businesses set up through the SOS of your respective state to avoid potential legal repercussions.
Thank you so much, Marosh. I think that's a pretty good overview of what the bill entails, but I think as attorneys, we have so many questions, like what that actually means in terms of execution. So I think the very first thing we would want to know is, why did FinCEN decide to enact the CTA in the first place? And like, why now in January 2024?
Yeah, so I'll answer that. I think the intent here is that if law enforcement have access to information about the beneficial owners, then they can't, the beneficial owners, meaning those who own or control these companies, then law enforcement agencies are going to be in a better position to either detect, prevent, or punish perpetrators of terrorism, of money laundering, and other crimes that can be committed through these private business entities in the United States.
Yeah. In terms of like actually making sure that we're following AML and like anti-terrorism efforts, I believe that the CTA requires us to report beneficial owner information. Could one of our panelists explain what that means in terms of actually reporting for your clients?
Yeah, so I'll continue on that line. So yeah, the beneficial ownership registry is what is being set up under the CTA. And so it's going to be a repository of information on who actually owns these companies or controls these business entities. And so, and Congress has recognized that, you know, millions and millions of entities are set up privately in the United States. And I think there was a report that came out that showed that the United States is one of the easiest places to launder money. And the world has become aware of that. And Congress wants to tighten up their controls on this money laundering or other crimes that are committed through our financial systems in the United States. And so by creating this repository of information, Congress and FinCEN will have access to this repository of information on who is actually controlling these private entities in order to detect and prevent these crimes from being committed.
Yeah. Can one of our panelists expand a little bit on what are the actual like information that you would be required to report for the repository? I think, Sam, that you had mentioned earlier too that so just to fill in here, I think, Sam, you had mentioned that part of the reporting guidelines includes, like, of course, you know, the client's name, their date of birth, residential information. Is there anything else?
Yeah, so the beneficial owners they have to be individuals. We're looking, you know, the government is looking to know who these actual people are, because when you set up companies, there's often these complex structures of subsidiaries with holding companies and higher holding companies, and there are these complex structures. So it's difficult often, and especially in money laundering, you want this complexity in order to hide who the real owners are, so the enforcement agencies aren't able to figure you out. I mean, that's the whole point. So by having to report who the actual individuals are, reporting what their full legal name is, what their date of birth is, what their residential address is rather than their business address, and then providing some kind of unique identification like a passport, a driver's license, or an identification card that's issued by the jurisdiction where they reside, and providing an image of that document all of that information is what's going to be required to be reported to FinCEN. And it really drills down to more personal levels so that these government agencies have access to people, not just networks of companies.
Yeah, I think it's a pretty comprehensive report of people's like biodata, I suppose, which I know that the UK has implemented that a few years ago, and I don't know what their success rate has been, but interesting to see what happens here in the US. On that same vein, so what does this actually mean for the lawyers? Lawyers such as yourselves, do you actually have the duty to report to FinCEN, and what does that mean for you?
Yeah, I think I'll take that one. I absolutely think the short answer is yes. As a lawyer, if you're involved in the entity formation process, I think the short answer is you need to be fully aware of this and the different ways that you have levels of responsibility. And I know that, my colleague and I may have some spirited debate about the scope of it, but like most things, this comes down to the actual facts. And just as by way of example, we do commercial real estate. We form entities directly for clients buying and selling real estate. And we are a direct filer, probably in to be seen, but we're a direct filer under the CTA, whereas Sam's firm is a little bit more like they retain a third party. So we are both covered under what is described as a company applicant, but we are under two different sub bullets maybe. I'm a company applicant as an individual who directly files the document that first creates the domestic company. And then Sam's firm, possibly, and I'll be putting words in his mouth, feel free to correct me, is the individual responsible for controlling such filing, that sort of thing. And so there's this different level. And I think it is going to impact what you as a lawyer need to collect from your client and report either directly to FinCEN or maybe you provide to a third party, because there are different levels and, there's going to be typos, there's going to be mistakes. Whose fault is it? And is the lawyer satisfying their fiduciary duty to the client by doing X? And it's a complicated question. Again, my short answer was yes, lawyers are going to be responsible. I'm a bit more pessimistic. I think that FinCEN, if you submit a Delaware filing today or in January 12th, and you're the organizer, and if you don't do that, the responsibility lies on the beneficial owners to report. However, as lawyers, if your name is the only name on the document, I think they're going to come after you and try to pin their duty on you, whether it's civil or criminal. I think they're going to impute more to you as a lawyer because that's the only person that they have available for recourse. So that's my opinion. We're all just kind of guessing on the future, but as a lawyer, we obviously owe a fiduciary duty. We talked about just knowing about this rule, about informing the client of their need to give us the information or to give the information directly to FinCEN. However, understand that I think most lawyers, like if you're like us, we're the ones filing the entities on behalf. So we're probably going to have that FinCEN account. And so again, it creates additional levels of duties of, okay, if you're the lawyer, if you tell your client to create a FinCEN account and file it, is that enough? If they tell you, yes, I went ahead and filed it, is that enough to absolve you of your responsibilities? I don't know. I mean, just speaking for myself, I know that I'm going to have a FinCEN account, January 2, I'm going to be on the website trying to create the account and going through all that IT pain so that I can do it for my clients. I think that's taking on additional responsibility, but that's my practice. And so I feel like that's a very long answer, but I think there is going to be some additional layer of lawyer responsibility. What that rises to in terms of the actual steps and what that rises to in terms of actual penalties, whether that's a FinCEN, civil or criminal, or that's just maybe just a fiduciary duty that we owe to our clients on a I guess, a contractual state basis. That probably remains to be seen, but I guarantee it's not going to be zero. It's going to be some heightened level. Maybe it doesn't go to 100 like I'm predicting, but I think it's something.
Yeah. Ron, I actually have a few follow-up questions on some of the stuff that you said. So before we get into what the actual penalties and liabilities are, number one, to clarify what you said, if an attorney is like the direct organizer, you believe that they are going to face more risk than maybe if they are indirect or they're hiring a registered agent, correct?
Yes, there's these third parties that file for you. So we talked about like CT Corp, Northwest Registered, and a lot of firms, I think Sam, utilizes them, and they're great. They can consolidate. They're very responsive. They do things well. And if you're filing a lot of entities, it can be a real time saver, and you just pass the cost to your client. I think that's a distinction in that you're not the direct filer anymore, but you are the person responsible for controlling the filing. And what does that mean? It's just slightly different. I'd say it's a lessened role of responsibility, but you're still responsible, for taking the client information that they provide to you, and then the law firm gets it, and then the law firm passes it to CT. There's all these steps for a typo or human error to be introduced, and so that's
And my second follow-up question is, when can attorneys start making FinCEN accounts, and which attorneys need to make one?
Yeah, so I've checked it, no, not super recently, but I checked it before this. There's no link yet. There's no website. I'll probably send an email in again. I always love bothering them, saying, when can we have the live link? But it's interesting, this is kind of like a side note. Florida has this like registration for foreign national ownership for China and Korea. And so I've been working with them. It's like the Department of Agriculture is responsible for it. It is like pulling teeth to try to get the form, even though they're required to produce a form months ago, and they just don't even have it. So it's like, we're in a weird spot. We physically can't even comply with the law because we don't have the ability to submit the form, even though that the legislator, commanded this agency to create a form. So, I say stay tuned to this channel, subscribe, because we will update once that link comes out. And I think every attorney should just make the account. You should just know what that process is, confirm your email, click around, familiarize yourself with that website and the interface and how long it takes. But yeah, I think you should create an account if you're creating entities for your client, because you're going to have questions from your clients too. Even if you're not the one filing on FinCEN directly, clients will ask you, can I give you my name with a tilde? Can I give you a hyphenated name? Or my passport has my maiden name dash this, but my driver's license is this name. I have a name change certificate. Which one do you want me to give you for FinCEN? It's going to be like, great question. Maybe the FinCEN website says, provide your current name, provide former names, provide known aliases, provide this. And so you would really be responsive to your client if you say, yes, give me all of your names. The FinCEN form online has a space for maiden names and aliases and alternate spellings. Or they might say, just give me your current legal name, give me your passport name, just pick one, because FinCEN only allows for one last name. So all sorts of these questions, we're just not going to know until it's game time. And it's trial by fire.
Love that. That's government bureaucracy at its finest. So good to know. I've received a couple questions in the chat that are relevant to this topic right now before we move on to our next topic. One lady has asked me, is the personal information that is going to be provided in this federal repository, is this publicly accessible, or is it private and only the government agents can look at it? I don't know if Sam or Marosh are able to.
I can answer that. So it's private information. It's only accessible by the agencies. It's going to be in a highly secured, double encrypted, whatever, within some kind of server in a federal database somewhere. And so it is private information. It will not be subject to the Freedom of Information Act. So companies that are trying to get information about beneficial owners cannot make a request to the Federal Freedom of Information Act to try and get that information. However, there are state agencies that will also have access to this information through subpoena power and through the judicial process. They can get access, but it's going to be carefully monitored so that that information is used for enforcement purposes. In addition, there are financial institutions that will have access to this information if those who have provided the information consent to it. So your bank, if you're going to get a loan or something, you can consent, and they will probably incorporate this into their loan documents, that you're consenting to give them access to the FinCEN repository every time you apply for a loan, so that they can double check that you're not some sort of terrorist or some kind of organization that's trying to commit crimes in the United States.
Okay. Yeah, this is super helpful. I think people were kind of worried if this ends up being like public client data or public data that's stealable or accessible.
Absolutely.
Good to know. I want to shift into our next topic, and then I'm going to ask a few more questions from there. So let's discuss what happens if you don't report, right? So what are both the civil and criminal penalties that an attorney would face if they fail to follow up with these due diligence guidelines?
So the different penalties would be applicable to the filer, basically. There are two individuals who qualify as company applicants. First, the individual who directly files the document that creates or first registers the reporting company, and the individual that is primarily responsible for directing or controlling the filing of the relevant document. So these would apply to both. Civil penalties include monetary penalties. A failure to comply with the CTA's reporting requirements can lead to significant monetary penalties. Under the law, civil penalties for non-compliance can reach up to $10,000 for each violation. Secondly, there are ongoing penalties. A CTA may impose those for continued non-compliance, and these can accrue on a daily basis. The specific amount of these penalties may vary depending on the nature and duration of the violation. Third is the injunctions. Court may issue injunctions ordering individuals or entities to comply with the CTA's requirement. A failure to abide by a court-ordered injunction can result in further legal consequences. Now, there are criminal penalties as well. In cases of willful and knowing violations of the Act, individuals may face criminal charges, which includes fines and imprisonment. And then secondly, there may be felony charges, which can result in severe criminal penalties, including substantial fines and further imprisonment for several years. We can see examples of this through how the OIG has been running their business with a lot of Medicare and Medicaid frauds. Thirdly, liability for false statements. Under the CTA, that's a separate offense and may lead to criminal liability, again, fines and imprisonment in there. It's important to note that the severity of the penalties will depend on the various factors, including the extent of non-compliance, the intent behind the violation, and whether it is a first time or a repeated offense, and also the duration of it.
Yeah. I mean, Marosh, thank you so much for walking us through this. So I think the biggest concern might be, hopefully the biggest concern might be like the financial penalties, right, that attorneys would face, and that the 10K for non-compliance, like how much is it that they are, is FinCEN going to be penalizing you per day? Because I feel like the 10K could be hit pretty quickly, right?
I believe I was reading about $500 a day for ongoing requirements, but now they will be directly contacting the filer. If it's your attorney or your CPA, or if you did it yourself, which I think a lot of people will be doing too. And it'll be our job, I think, that we should go back to our clients that we've had over the years and send these directions out to them that you have to get this done timely. If you don't, this is what's going to go through. And for a daily basis, for example, it's the 500 is what I think we were discussing earlier. And now for companies that have already been created before January 1st, 2024, they have the full year till the 1st of January 2025 to file this paperwork. For companies that are created anytime after the 1st of January 2024, they have 30 days to do that. And that liability, if we are, or if there's a third party creating these companies, like Ron's company does it themselves, my company, we do it ourselves. Sam, the third party that they're doing, because they're contracting out, I believe that will still put the onus on Sam to follow through with that. Once we are registering, I think it's just going to go hand in hand, and it'll be the attorneys or the CPA's job to go ahead and do this filing for them in a timely manner within 30 days.
So to recap, because I think someone in the chat asked this as well, if you are a previously organized company, they have, prior to 2024, you have from January to the following January 2025, 1 year to get in and satisfy the reporting guidelines, correct?
Exactly, yes.
Good to know. So I also wanted to ask, are there exemptions? Like, does every single company have to report and file? Like, who is exempt from this act?
Yeah, there are exemptions. So the act defines, basically, it's very broad. It defines all companies within the United States unless you meet an exemption. So companies, and what they mean by that is if you file a piece of paper with the Secretary of State in the United States or in a US jurisdiction, so it could be with a tribal nation, it could be with a territory within the United States, it could be in Puerto Rico, it could be in Guam. But if you're filing a piece of paper with a jurisdiction in order to get a charter to operate a business, then those companies are required to report unless they meet an exemption. And the exemptions would apply basically to companies that are already required to report to the federal government for whatever reason under some other regulatory scheme. So, for instance, the Securities and Exchange Commission or the Securities and Exchange Act and the Securities Act of 1933 and 1934, they already require companies that are publicly traded to register with them and to do annual filings and quarterly filings with them. So those companies are going to be exempt because the federal government already has access to the beneficial ownership of those companies. So any publicly traded company like Google, Apple, Microsoft, those companies are not going to be required to report beneficial ownership information under the CTA because that information is already available. And then there are a lot of other companies, types of companies that are subject to regulations that require this information to be reported to the government. Those include governmental authorities. Those include banks, credit unions, bank holding companies. They're subject to banking laws that require certain reporting requirements. And then you have money transfer companies and bank holding companies and depository companies that are already registered with FinCEN. And so FinCEN already has access to information from these companies. So if you're a bank holding company or a money transfer company, then you're already registered with FinCEN. There's no requirement to report under CTA. And then you get into companies that deal in securities. So broker dealers, exchanges and clearing houses, clearing agencies, and any of the registered entities under the Exchange Act. All that information is reported to the federal government on an ongoing basis. So they're exempt from this registration requirement. And then also, if you have investment advisors, they're subject to the Investment Company Act. So if you have investment companies, you have investment advisors, you have pooled investment companies, you have venture fund advisors, all of those type of companies are going to be exempt from these reporting requirements for the same reason. And then insurance companies and state licensed insurance producers, those companies have to provide this information under separate regulations. So obviously they're not going to be subject to that. Public accounting firms, they have to register under the Sarbanes-Oxley Act. And so they're not going to be subject to that. And then different types of utilities, large utilities, public utilities, they're not subject to it. And then there are tax exempt entities. So 501c3 entities, they have to provide this information to the IRS. So this information is available to the federal government. And then any entity that exclusively provides assistance to 501c3 entities are also exempt. And then, of course, if you have very large companies that have a U.S. presence, that have 20 or more employees in the U.S., and their U.S. domestic revenues are at least 5 million, they won't be subject to these reporting requirements. And I think when you look at the exemptions overall, you're really looking at the government already has access to a lot of information already. And what this act is designed to do is it's designed to get some of the private information out of some of these small private shell companies or front companies that are set up for illicit purposes. These large companies, they're set up, they're well known, they advertise, they make filings with the government. The government's not that worried about those companies. In fact, the government works with a lot of those companies in order to monitor national defense and issues like that. But these small shell companies that are set up maybe in Nevada or in Wyoming or in Delaware or in jurisdictions where that information can be kept private, and those jurisdictions don't require you to report who owns these entities, that's where the concern is. And that's where the CTA is being designed around, to extract that information and create this repository so that law enforcement can crack down on those crimes.
Yeah. So it seems, I think, Sam, you mentioned there are 23 exemptions or so. And so to me, it seems more like a process of elimination, right? So if you are not already, if your company doesn't already operate in an industry that has very stringent reporting guidelines to begin with, now therefore you do have to report under FinCEN, right? Is basically what I'm hearing. So no way getting around it, unfortunately, unless you really fall under some exemption that you don't have to.
Yeah, the only thing I can think of would be is if you operated as a trust, because trusts aren't required to file a piece of paper with a company, with a jurisdiction. But that is also risky. A lot of people are going to operate that. There's not limited liability operating through a trust. So
good to know. I know. Which brings me to the next question too. It's like, we're hosting the CLE, right? And like, we have, of course, attorneys like you who are constantly learning and like keeping tabs on existing legislation that's being passed. If you were an attorney, maybe who is like a solo or a smaller firm, or you're just not aware of this new act that's being implemented, what happens in that case?
Yeah, well, I'll speak to that. I'm all the doom and gloom side, but I definitely think it could rise to the level of malpractice, because this, for our perspective, has been in the news for years. I mean, this thing is not new and it's not quick. It's the federal government. But these are the types of things that if you're not forming entities every day, I mean, I think our office probably files stuff every single day. And so we're constantly having this dialogue. But yeah, this is part of, the advice to younger lawyers. You've got to start to develop somewhat of a specialty so that you are abreast of news for legislation, different changes that impact your advice to clients, because this is clearly a big deal and we're all hyper aware of this and really digging into the minutia. But as you develop your practice, you can't know everything, and you can't know everything across multiple jurisdictions and federal and state law and all these sorts of rules of procedure. And this is just an example, I think, of the growing complexity. Government compliance has not gotten easier. I've been practicing for 15 years. It has only increased. And so it's all I can do to really just focus on one area of the law. And yeah, it's definitely, I don't know if it rises to malpractice if you don't tell the client, but these are the types of things. It just looks bad. I think if you don't know it and the client has to ask a question and you're like, oh, I'm not sure if that's in effect yet, let me get back to you. It's definitely something that you should be aware of if you're doing entity formation or working in this corporate arena.
Good advice for the younger lawyers listening in. I think this brings me actually to my next question, which is, so all three of our panelists today work in slightly just different or more distinct areas of practice. And my question to all three of you panelists which I hope each of you could answer, is how does the enactment of this new act going into effect in 2024, how is this going to change your due diligence practice, as well as like your formation process for the corporate clients that you work with?
I can start us off. We're just doing enhanced due diligence on all our cases. The increased scrutiny where our attorneys will need to conduct extensive due diligence to identify and verify beneficial owners of corporate clients, especially those entities with complex ownership structures. We have been asking clients to do a better job record keeping. We are having to do verification of ownership, ensuring the accuracy of the information that'll go into the BOI. That'll be critical to avoid information. We need to employ additional verification methods, and I assume many such companies will pop up through the next year. We're also doing compliance checks where attorneys in general, I think, will need to incorporate the CTA compliance checks into their general intake process to make sure that their clients are meeting the reporting obligations for when we're setting them up, because at that time we will have to file the paperwork. And if they're doing it themselves, then we have to let them know, but preferably in writing to avoid malpractice, that they need to be doing the correct filings with the exact information that's required.
Thank you, Marosh. Ron and Sam, did you guys want to share how you're?
Yeah, I mean, I think the only thing I would comment is about the website, right? So the forms or the information as a direct filer, if we're the attorney that's going to be submitting to FinCEN, we can't even make an account yet. There's no website. And so that'll be available Jan 1. So it's like simultaneously when the law takes effect, and if I'm filing an entity on Jan 2, I have to navigate this new website and process. And frankly, we have no idea what it looks like. I know there's some questions out here, like, is there a form that LLCs can fill out to ensure compliance? Any links would be appreciated. Well, Joy, I would appreciate it too. But the reality is we don't have anything. We have the text of the language, and we have a general idea of the bullet list. But, you know, kind of before this call, we were chatting. It's a huge issue of what exactly meets their requirements. You know, if there's a typo, is it attorney liability? If the client gives us information that we think is clearly wrong, or, you know, they state the name spelled differently than on their legal ID, what is the lawyer supposed to do? I think probably you're supposed to reject it, but are you able to submit that form? And you know, I'm sorry we don't have better answers, but yeah, there's no form, there's no website yet. It's just all coming really quickly, and we're gonna find out as quick as we can.
Yeah, I'll add to that. I think it's important to remember with the CTA, there are basically 3 different reports that you have to make with the CTA. There's the report on the company itself. So you need to provide the full name of the business. You need to provide any trade names or DBAs. You have to provide the US address of the business, the jurisdiction where it's formed, and the EIN or other tax ID number. So that information is just for the company itself that you have to provide. And a lot of that information is information that as lawyers, we're going to be gathering during the formation process. Well, we're not going to be gathering the EIN. We'll be probably filing for that. But most of that information we will gather in anticipation of forming these companies. And then the second part, the second thing that you have to report is the beneficial ownership information. And often my clients don't know when they're forming their companies, they don't know who the beneficial owners are going to be, because they may be setting up a real estate syndication. So they're setting up an LLC that will be the ultimate holding company for the real estate. But that company is going to be owned by a separate company, and that separate company is going to conduct a private syndication offering to raise capital to provide the equity that's needed to close on that real estate deal. So that separate company then has no owners in it when it's set up. And the founders don't know who those owners are going to be because they haven't raised that capital yet. So they're going to go out and raise that capital. And there may be an investor that's going to own 25% of that company, and they don't know it yet. And so they might not raise capital within 30 days. It may take them 60 days to raise that capital. So it creates a problem, like Ron was saying, where we don't know exactly how FinCEN is going to enforce this. We don't really know how it's going to apply. We can't set up our own account with FinCEN yet to see what boxes we have to check. But we do know that we can gather the information on the reporting companies. And then my own personal solution to the second issue with beneficial owners is I'm going to require that my clients just provide me with information on who the founders are going to be and who those who control the companies are going to be, because I think that we can probably get a good estimate on who those parties will be, because they're typically going to be the sponsors in the deals that I do. And those parties will be reported within 30 days. However, if that changes and a beneficial owner comes into the mix after they raise capital, then we have 30 days to file an update with FinCEN and list who those new owners are on the beneficial ownership report.
So Sam, I'm curious.
And then the third thing that we have to report is the company applicant. And that's something that Ron and Marosh have both talked about when it comes to attorney liability. So company applicants are going to often be attorneys or CPAs. They're the parties that do the filings with the Secretary of State. And there's going to be a report required that you file that you're the company applicant. And so that's another report that contains information about the attorneys that are assisting in the formation process in doing these filings. And so with the company applicant aspect, we don't have to file who the company applicants are on companies that were formed prior to 2024. That information is irrelevant, and they're not asking for that information in the Act. They're only asking for company applicant information on companies that are formed after 2024. So starting in January, if you form a company on January 1st, 2024, then you as the attorney are going to have, if you file the documents, you're going to have to list that you are the company applicant on a report. However, to Ron's point, companies that were created prior to 2024, if you're the attorney that filed those documents, you may be the only one listed on a filing with the Secretary of State. So FinCEN has no choice but to talk to you and find out who the beneficial owners are if that company doesn't file that report in that 1-year grace period in which they have to file that report.
Sam, I just want to jump in here. So two questions to your explanation. Number one, you listed 3 CTA reports that have to be filed. I just want to recap them. First is the report on the companies. The second is the beneficial owner information. And remind me, what was the third one that you stated?
The third is the company applicant.
The applicant,
So
right.
That's us.
Right.
In many cases. In some cases, it may be the founders. They just bypass their attorneys and they just go to the Secretary of State and form their company. If that's the case, then they're the company applicant and the attorneys aren't in that report. But that's the third report.
The second question I had, which I think Ron and Sam had discussed this a little bit earlier, was is any attorney whose name is listed on any of these corporate documents, are they facing the same risk?
Yeah, I think the answer to that is no. We're primarily looking at what is publicly filed or sent to SOS, who may be cooperating with FinCEN in passing information. But if you're an attorney that's listed on an operating agreement or a meeting resolution or private documents that are not otherwise filed, I don't think you're going to fall under this same specter. It's really just those initial people that submit SOS documents.
Okay, thank you. So I think I have a few questions in the chat. I was hoping we can answer as well. So one attorney asks, will all attorneys have subpoena power to gain the beneficial ownership information. For example, if there was ever a civil lawsuit amongst a business and its partners, could they file for a subpoena to get that BOI information?
I'll let Sam, but I think Sam was saying no, it's not for private suits.
Yeah, I mean, if you're in litigation and you have a private company, it's not going to be that hard for someone conducting a deposition to ask you directly who the beneficial owners of your company are. But for them to access the repository of information with FinCEN, the answer is no.
Okay.
Well, I think it would be a good contradictory point of evidence. If they lie on the stand, you can pull this out from discovery. But yeah, I think we, and again, my mind is kind of blurring between federal law enforcement, certain cooperation with state agencies, IRS, I think has access, but it's not a FOIA subpoenable database. And it probably is not open to civil subpoenas for this information.
That's right.
Yeah. I kind of wanted to jump into Ryan's question. Ryan asked, could you clarify who will be considered a beneficial owner? So that is something that's kind of stated beyond just the 25% ownership interest. Substantial control is also kind of that ownership. But what about, Sam, to you, in your syndication example, are you counting limited partners as a beneficial owner or change in ownership?
Well, if an LP owns 25% or more of the company, then you have to look to who the owners of the LP are. And if it's a single owner, then that single owner is imputed to own 25% of that syndication. So they would be a 25% beneficial owner. And so you have to look up the chain until you find an individual who actually owns 25% or controls 25%, because often LPs are controlled by the general partner. And so
yeah, that's what I was getting at. I feel like as an LP, they wouldn't trigger it, and then individually, very few single LPs would rise to that level. So
yeah, I mean, this is going to be tricky analysis that the clients probably are not going to be able to do on their own. They're going to have to rely on their attorneys to analyze the law and figure out exactly who is a beneficial owner. It's not going to be very straightforward, because you're looking at both control and ownership.
yeah, that's what I thought.
Very different.
And we have springing situations. I mean, especially kind of in the multifamily side now, you've got pref equity coming in. They may not have control today, but 6 months from now they will. Does that trigger the duty when they exercise their right to take control and foreclose on equity?
Yeah, that's an interesting point that you bring up, because one of the exemptions from being a beneficial owner is a creditor. And often banks will be a springing member, or they'll have an appointee as a springing member under a special purpose vehicle to, if the loan goes into default, they can spring into membership in the company. But if they're a creditor, they're not going to be required to report their beneficial information, because they're exempted from being a beneficial owner if they're a creditor.
Marosh, did you want to jump in here?
Yes, I think one of the things that Ron mentioned, that is bringing interest, say it's a family member, for example, they will end up becoming a substantial control person in the company, and they will have to update within the year if that ownership interest changes. So the answer to that question is yes. And the substantial control that we were talking about, it is based on a variety of facts and circumstances, but it also means it could be a senior officer within the company that has authority over appointment or removal of other senior officers, or a board of director, and also somebody that has the ability to direct, determine, or have substantial influence over important decisions. And to that, I will also add, although it may be an LLC or an LP that is not directly an owner of the corporation that you're reporting, but if there's a management company associated with that, then you will have to report that, even if they're not direct percentage owners. And I think this will also be important for healthcare industry, such as hospitals, et cetera, because a lot of times they have situations like that, which may or may not be acceptable to Medicare or Medicaid. But still, you will have to go ahead and report them as into the BOI registry as well.
Yeah. So I think we have only a couple minutes left here, but from what we've been able to gather from today's discussion, right, is that there is a lot of gray area and there's a lot of questions that I've still don't have answers for. So before we end today's CLE, I wanted to ask our panelists, what is information that you wish you had or further information that you would like to know going into 2024?
I'll start. I mean, I'm going to answer this a little bit different than I think what you're asking, but what I would like is information from my clients, and that's the biggest area where I want information. So I'm creating a database, and I'm reaching out to all of my clients, and I'm creating a form where they can fill out beneficial owner information, and they can submit that form so that it'll populate a database that I've created, so that I have access to all information related to beneficial owners, so that during that grace period of 2024, I can make the filings and I don't have to worry about the liability as an attorney or as a company applicant. And so having access to that information is going to be of most importance for me right now.
Ron and Maria.
I think for me, it's really just wanting guidance on the definitions of beneficial owner. I know I've seen a couple of chat requests, but it's a huge deal, especially in real estate. We've got asset protection people and estate planning that are moving things around constantly, because kind of at the end of the day, the same person is running the ship, but they're running the ship in different capacities. Sometimes it's as a owner and sometimes it's as a trustee or as a manager, but they don't have the ownership anymore. And, it just makes my life impossible if I'm kind of taking on responsibility for compliance. A client comes to me and they've got 15 LLCs. How do I keep track of all those beneficial owners when they're swapping them around with different partners or within the family for estate planning? So, I think that's my number one goal. I wish I knew what a beneficial owner was. Is it just an individual? Do I have to report if somebody changes from ownership to control? How about that? But the same person. So.
To answer that, I think we won't have to report that, because ownership and control both have to be reported. So if it's somebody who goes from ownership status and the son takes over, for example, add the son onto it, but leave the father in there, because if he's still, has substantial say in how they're running their business.
Yeah, I just don't know if when we submit it, if it says, person A, owner, person in percentage, then that becomes inaccurate, and it becomes a data point that's just, it's not true. This is my prediction. I don't think the form is going to be so broad as just like owners or control, and you just do a list, a field, a box. I think it's going to be so specific. And so in your example, if the son comes in and transfers over and the dad's still running the show, that's a different submission. The form looks physically different than what the structure was before. So
I'm excited to see what the forms will look like. I assume they're going to throw out a wide net. And right now, this process over the last year has been honed in by, and I speak to Medicare and Medicaid a little bit more because I do those on a daily basis. This program is already going on through a lot of these government agencies. So I assume they're just probably maybe using the same contractors to set up these forms, and they will pick up from that. So we may have to go in within the allotted time and just change that information, the percentage, if there's a box for that. If not, then we add in the substantial ownership and just move the names around and add people that have been added on. For example, for some state related contracts, you have to report to the state if the change is over 33%, the ownership change. So they may put in a clause like that, that if the change is above, I don't know if they're going to do 25%. It doesn't seem that large, but you know, we'll see. When they add that on there, onto this online form, we'll know eventually.
So with that, I think we will end today's discussion there. Just for everyone listening in today, thank you so much for joining. Again, I am Rahila Hassan. I'm the chair of the Transactional Law Committee with DAYL. This is our first time hosting a transactional CLE in a while. So we are very, very grateful to have our panelists attend and especially speak on a topic of which there is, I think, a lot of confusion in the corporate real estate business world. So thank you again to our panelists. I know that Sherry has posted the CLE credit number in the chat, as well as this recording, this CLE Zoom is recorded and we can access the recording at a future time. If you guys have any questions or are looking to reach out to the panelists, Sherry can provide their email addresses and their firm names and you can reach out to them directly. But thank you guys again so much for tuning in.
Thank you.